Criminal interpretation number 777, hit and run, that involves no negligence of the driver and with minor circumstances. Date 2019. Issue: do the elements of Article 185-4 of the Criminal Code violate the void for vagueness doctrine? Does its sentence violate the principle of proportionality? Holding: Article 185-4 of the Criminal Code, as revised and published on April 21, 1999, provides that one who causes accident resulting in death or injury while driving motor vehicle and flees shall be sentenced to imprisonment for not less than 6 months, but not more than 5 years. On June 11, 2013, the provision was revised and published, and the sentence was raised to not less than 1 year, but not more than 7 years. Other elements of the crime remain the same. The possible scope of the accident element might include accidents due to driver's intention or negligence, or accidents not attributable to the driver's intention or negligence. So there are two kinds of accidents. First one is accidents due to driver's intention or negligence. And the second one is accidents not attributable to driver's intention or negligence. For example, due to force majeure or the intention or negligence of the victim or a third party. Accidents caused by the driver's intention or negligence clearly are covered by these provisions, so there is no ambiguity with it. But where other situations where an accident is not attributable to the driver's intention or negligence can be subsumed under causes accidents is not yet understandable or foreseeable to the people being regulated. Within this scope, the latest of the provisions contradict the void for vagueness doctrine. Therefore, the part in contradiction shall become null and void from the date of the announcement of this interpretation. Article 185-4 of the Criminal Code, as revised and published on April 21, 1999, hereinafter referred to as 1999 dispute provisions, are not inconsistent with the principle of balance between crime and punishment established in the Constitution, and do not violate the principle of proportionality. However, the 2013 dispute provisions made statutory penalties or imprisonment for not less than 1 year but not more than 7 years. This renders it impossible to convert imprisonment into a fine for those who committed minor crimes, and thus constitutes an obviously harsh punishment for cases with minor circumstances. It is to this extent inconsistent with the principle of balance between crime and punishment. So the balance between crime and punishment as a principle is established in the Constitution, and it is inconsistent with the principle of proportionality stipulated in Article 23 of the same. This violation shall become null and void for not more than 2 years from the date of the announcement of this interpretation. Reasoning: I will skip the background here. Okay, and I will read the reasoning part from the reasoning. The above 3 petitions, so the part I have skipped, The above three petitions are all in conformity with the requirement outlined in Article 5, Paragraph 1, Subparagraph 2 of the Constitutional Procedure Act and are hereby accepted. In addition, concerning the hearing of their court's various cases as shown in the attached table, the petitioner judges from Yan Unit of Taiwan Taichung District Court, Criminal Division 8, etc., rule to stop the proceedings and apply to this court for constitutional interpretation, viewing that application of the 2013 dispute provision was in doubt of conflicting with the Constitution. The 16 petitions, a total of 17 original cases, are in line with the requirements for judges' petition for constitutional interpretation as indicated in JY Interpretations number 371, 572, and 590, and these petitions are accepted. The above petitions concern the 1999 dispute provision or 2013 dispute provision, except for differences in the degree of punishment. They have the same constituent element. Except for differences in the degree of punishment, they have the same constituent elements. Given the dispute over unconstitutionality has its commonality, the cases are heard together. Hence, this interpretation was made for the reasons outlined below. First, the reach and scope of constituent elements, meaning for accident, stipulated in 1999 provision and the 2013 provisions, partly violate the void for vagueness doctrine, and this part shall become null and void. Limiting people's rights by law. Limiting people's right by law, based on the rule of law, requires that its constituent elements conform to the void for vagueness doctrine, so that the regulated can foresee the legal effects of their action. This is to ensure the legal function of advanced notice, the clarity of law enforcement criteria, and the realization of the purpose of the law. According to this court's past interpretation, the meaning of the concept used in legal provision should be based on the latest of the law, the legislative purposes, and the overall relevance of the legal system. They also must be understandable and foreseeable by the regulated and verifiable by judicial review. Only then can it be not in contradiction with the void for vagueness doctrine. However, for criminal law provisions that restrict people's personal freedom, their constituent elements should be subject to more strict scrutiny to confirm whether they conforms to the void for vagueness doctrine. The 1999 dispute provision provides that one who causes accident resulting in death or injury while driving motor vehicle and flees shall be sentenced to imprisonment for not less than 6 months, but not more than 5 years. The 2013 dispute provisions raises the punishment by establishing that one who causes accident resulting in death or injury while driving a motor vehicles and flees shall be sentenced to imprisonment for not less than 1 year, but not more than 7 years. The above two disputed provisions refer to the criminal law provisions involving the restriction of the people's physical freedom. Whether their constituent elements are clear or not should be subject to more stringent review. Its judgment should therefore be based only on the latest of these provisions and their overall relevance to the criminal law system without referring to other relevant laws. There are 4 constituent elements in 1999 dispute provision and the 2013 provisions. Drive motor vehicle, cause accidents, result in death or injury, and flee. The possible scope of accidents element might include accidents due to driver's intention or negligence, or accidents not attributable to driver's intention or negligence. For example, due to force majeure or the intention or negligence of the victim or a third party. Accidents caused by the driver's intention and negligence clearly are covered by these provisions, judging from their latest and overall relevance to the criminal law system, so there is no ambiguity with it. But whether other situations, whether an accident is not attributable to driver's intention or negligence, can be subsumed under causes accident is not yet understandable or foreseeable to the people being regulated. Within this scope, the latest of the provision contradict the void for vagueness doctrine. Therefore, the parts in contradiction shall become null and void from the date of the announcement of this interpretation. The range of punishment in 1999 provision does not violate the principle of proportionality. However, the range of punishment in 2013 provision is evidently harsh for minor cases and is contrary to the principle of proportionality. Personal freedom shall be guaranteed to the people as clearly provided in Article 8 of the Constitution. Punishments that restrict the liberty and security of a person and severely restrict the fundamental rights of the people should be the last resort, even if the legislator, to protect the specific important legal interest that conform to the constitutional value, considers that the punishment is conducive to the achievement of the end when there is no other equally effective means to achieve it in a less harmful way. It may limit the freedom of the individuals through criminal norms. But the restriction of punishment on the liberty and the security of a person must be proportional to the legal interest it intends to safeguard. In particular, only if the level of legal punishment is proportionate to the harm caused by the accident and the severity of the perpetrator's responsibility may it be consistent with the constitutional principle of balance between crime and punishment, posing no conflict with the proportionality principle provided in Article 23 of the Constitution. The 1999 dispute provisions were amended to maintain traffic safety, strengthen rescue, reduce death and injury of victims, and promote drivers to provide immediate rescue to victims after the accident. On the other hand, 2013 dispute provision increased the punishment to imprisonment for not less than 1 year but not more than 7 years. The reason for amendment is briefly as follows. National Policy Agency of the Ministry of Interior recorded that during 2008 to 2011, the hit-and-run accidents that caused injury and death tended to increase years by year. In view of the fact that Article 185-3 of the Criminal Code has been revised 3 times to increase the statutory penalty to prevent hit-and-run offender from taking chance, which may lead to delaying the victim's chances of seeking medical treatment for survival, and losing precious time for treatment, and to discourage hit-and-run offense. The statutory punishment was then increased to sum up the provision of the 1999 dispute provision and 2013 dispute provision safeguard important legal interests such as protecting people's life and traffic safety on roads. Hence, their purpose is still legitimate. In addition, it is not unhelpful to take criminal measures to prohibit drivers from leaving the scene, maintain traffic safety, and avoid secondary accident, and reduce the death and injury of the victim. Furthermore, when the 1999 dispute provision was issued, the statutory punishment of not less than 6 months prison term but not more than 5 years was made regarding the crime of abandonment of Article 294, Paragraph 1 of the Criminal Code. Neither the abandonment nor escape directly harm the life and the body of a victim, but led to increase the risk of the victim's death or injury. In other words, the connotation of a crime is similar, thus it is not inappropriate to legislate the same statutory punishment. For the criminal acts that meets the constituent requirement as stipulated in 1999 dispute provision, the courts have the liberty of applying different punishment degrees according to different circumstances of the specific cases, so that the cases with minor criminal circumstances may be subject to an alternative imposition of a fine, following Article 41, Paragraph 1, first sentence of the Criminal Code. This will avoid the implementation of short-term deprivation of a victim or service of social labor, which may lead to malady of unduly hindering the actor's return to general social life. Therefore, to avoid excessive severity in individual cases, through the exercise of a judge's discretion, the part on the range of punishment outlined in 1999 provision is not inconsistent with the balance of crime and punishment established in the Constitution, and does not violate the principle of proportionality. As mentioned above, 2013 dispute provision raised the statutory penalty because criminal statistics at the time of the amendment show that hit-and-run incidents involving death and injury tended to increase year by year. In addition, heavier punishment was imposed to prevent delay in medical treatment of injury due to offenders taking chance. Moreover, in addition, heavier punishment was imposed to prevent delays in the medical treatment of the injured due to offenders taking chances. In this regard, it is not entirely inappropriate for 2013 dispute provision to raise the statutory penalty. However, there are possible significant differences in the severity of criminal circumstances of hit and run. Among them are the circumstances of minor crime, such as circumstances where the victim has suffered minor injury and does not need urgent medical treatment, or other similar circumstances that hardly infringe on the legal interest that 2013 provisions were intended to protect. For instance, where the victim is not incapable of self-help and the perpetrator returns to the scene for rescue or takes other necessary measures within a certain time after escaping, or when the perpetrator, although having left the scene, immediately inform the police or appoint another third person to perform rescue or take other necessary measures on his or her behalf, or other similar subsequent behavior that help to protect the legal interest. However, the 2013 dispute provision made the statutory penalty not less than 1 year but not more than 7 years mandatory in all scenarios. This rendered it impossible to convert imprisonment into a fine. For those who committed minor crimes, and those constitute an obviously harsh punishment for cases with minor circumstances, it is to this extent inconsistent with the principle of a balance between crime and punishment established in the Constitution, and it is consistent with the principle of proportionality stipulated in Article 23 of the same. This violation shall become null and void for not more than 2 years from the date of announcement of this interpretation. Before the authority concerned amend 2013 dispute provisions based on the intent of this interpretation, courts at all levels should still try the cases according to law where a driver causes an accident out of his or her intentional negligence and freeze, and there is no circumstances of obviously too harsh punishment for a minor offense. So this is a important part. I will read again. Before authorities are concerned, amend 2013 dispute provision based on the intent of of the interpretation, courts at all levels should still try the cases according to law, where a driver causes an accident out of his or her intentional negligence and freeze, and there is no circumstances of obviously too harsh punishment for a minor offense.